La Cour. I declare open this public hearing of the Grand Chamber of the European Court of Human Rights. The purpose of this hearing is to make public the holdings of the Grand Chamber that have been adopted today in the case of Kovačević against Bosnia and Herzegovina. The parties to the case, that is to say, the applicant, Mr. Slaven Kovačević, and the government of Bosnia and Herzegovina, represented by their acting agent, Ms. Monika Mijic, have been informed of the organization of this public hearing, which is being broadcast live from the court's hearing room over the court's website to ensure its public character. Also, the representatives of the third parties who intervened in the case, that is to say, the government of Croatia and the High Representative for Bosnia and Herzegovina, have likewise been informed. I greet the parties and the third parties in the name of the court. The decision that I have taken to proceed directly to making public the holdings of the Grand Chamber in this case is exceptional. Ordinarily, the judgments of the Grand Chamber are delivered some time after the examination of the case has concluded, when the text of the judgment has been finalized in all respects and is ready for publication. In the present case, however, and most exceptionally, I have considered it justified to announce immediately after its adoption the findings that are made in the judgment on this case. This decision rests on the exceptionally sensitive nature of the present case and the intense interest that these proceedings have attracted in the respondent state and the wider region. For these reasons, I have considered it necessary, for the sake of protecting the integrity of the judicial process that has taken place in this case, to proceed in this manner today. I shall now briefly indicate the subject matter and the procedural history of the case. I would clarify that the indications given are purely informative. They are not to be understood as part of the judgment, nor as in any way binding to the court, on the court. The case principally concerns the applicant's allegation of discrimination against him in the exercise of his right to vote. He complained that in the system of elections for the House of Peoples of Bosnia and Herzegovina, he could not vote for the candidates of his choice because of the requirements that apply in that context. He made a similar complaint in relation to the system of election of the members of the presidency of the state. He relied on Article 14 of the Convention, taken in conjunction with Article 3, Protocol 1, and also on Article 1, Protocol 12. The procedural history of this case before the court is as follows. The application was lodged with the court on the 30th of August 2022 under Article 34 of the Convention. It was allocated to the fourth section of the court. A chamber of the fourth section delivered its judgment on the case on the 29th of August 2023. Subsequently, the acting agents of the government requested that the case be referred to the Grand Chamber under Article 43 of the Convention. On the 14th of December 2023, the panel of the Grand Chamber accepted that request. The Grand Chamber held a public hearing in this case on the 20th of November 2024. Today, the Grand Chamber completed its examination of the case and formally adopted its judgment. It is therefore this date, the 25th of June 2025, that is to be taken as the date of judgment in this case. I will now read out the operative provisions of the judgment. The Court, 1, holds by 16 votes to 1 that the applicant's complaints under Article 3, Protocol 1 to the Convention, taken alone and or in conjunction with Article 14 of the Convention regarding the indirect nature of the elections to the House of Peoples of Bosnia and Herzegovina and the amendment of certain electoral rules on the day of the general elections of the 2nd of October 2022 fall outside the scope of the case as submitted to the Grand Chamber. 2. Upholds by 16 votes to 1 the government's objection to the admissibility of the application on the following grounds. A. By 16 votes to 1 that the applicant has abused the right of application within the meaning of Article 35, paragraph 3a of the Convention. B. By 12 votes to 5 that the applicant lacks victim status under Article 14 of the Convention in conjunction with Article 3 of Protocol 1 to the Convention and Article 1 of Protocol 12. 3. Holds unanimously that it is not necessary to examine the remaining inadmissibility grounds relied upon by the government. The complete text of the Grand Chamber's judgment, in accordance with Rule 74 of the Rules of Court, will be published in due course. The parties and the public will be further informed in this regard. This concludes this public hearing, and I accordingly declare it closed.